One would be, believe it or not, still swap data reporting. There are a number of enforcement actions we've been involved in and investigations we continue to be in with clients where the focus is on getting it right and making sure you have the processes in place to get it right. In particular, it seems to me that the Commission, CFTC, is focused not only on reporting, but also on what the broader systems impact is at the company. In fact, we were involved in a case that settled last fall, where in addition to reporting issues, there are also allegations that they failed to comply with system safeguards requirements as a registered exchange. And I believe that's going to be an area of continuing focus by the regulators. So in addition to enforcement, we're doing a lot of work on registering new exchanges, new platforms to trade new kinds of derivatives, which is a very exciting area. Those markets are purpose-built to address a number of the changes and developments that are going on in the 21st century, including climate change. So it's an exciting time to be involved in that. And in addition to that, we continue to advise a number of clients in the digital asset space on enforcement actions, unfortunately, but as well as sort of modifications to their products and services in response to a very aggressive regulatory and enforcement agenda. There's a substantial challenge as to what they are within the frameworks of how US laws define sort of an investment or an instrument. Are they commodities or are they securities? I tend to believe as a general proposition that something that is non-fungible would struggle to be considered a security. Now, wouldn't you know it, there are people in the market that are creating things like fractional NFTs and other things like that, where the line may be more blurry. So I think there is a continuing focus on what kind of product is it, and therefore, once you know that, are there regulatory requirements I have to follow? You know, do I need to be a securities exchange, a securities broker-dealer? Do I need to, if I'm a platform, be a designated contract market with the CFTC or a futures commission merchant with the CFTC as well? And so that's a fundamental challenge that people are dealing with. And then I think in addition to that, sort of the contractual issues are out there in terms of how do you apply traditional contract law to, you know, fundamentally a new asset class. And so I think that's an area where we see the law evolving in real time. In that case, just between parties negotiating rather than the government coming in and dropping the hammer in an enforcement action, which is a good thing. How decentralized are they? I think that the government is always going to try to find a point of centralization and argue that that specific centralized thing is in fact something that needs to be registered, let's say, as an exchange. Right now, the government is pursuing the Uki DAO after having charged and settled with the gentleman who created an LLC that ran a network that they said had failed to register. No sooner did they do that than they went out and charged the DAO as a legal person with similar violations of the law. And I think the challenge there is, well, who do you sue? Who do you even serve process on to sue? And to my way of thinking, what they've done is tried to sue all the people that hold governance tokens. And I think it's kind of ironic that you believe that the best way to protect a market and its participants is to go out and sue them. So I think that is just a square peg in a round hole. And I think that will be a continuing challenge for the industry. How do you decentralize, but work within a legal framework that for going on 100 years is essentially a presumed centralization? This is an area where we've seen an increasing amount of activity. At the firm, I work regularly with my colleagues in the white collar practice because we believe that at any point when there's a regulatory issue that's raised by an exchange or the CFTC or even your own broker, there's a very strong possibility that it could wind up being referred, if it's severe enough, not only to the CFTC if it's a broker or an exchange, but also the Department of Justice. They have a very active task force in that space. And some of the theories they bring are not only commodities fraud, but the same set of facts would support a violation of either money laundering laws, which we've seen. I was involved in a charging decision on something like that at the CFTC against a major non-US platform. Anti-money laundering laws is another area where we've seen some substantial challenges as well. And so I think what companies should do is think about their approach to compliance holistically. You can look at the recent guidance and the litany of guidance from DOJ as well as the CFTC on not only things like cooperation credit, remediation and self-reporting, but how to have an appropriate corporate compliance program. And I will tell you from the other side, when I was in government, that if you have a meaningful commitment to a good corporate culture and you have an effective remediation plan, you can substantially reduce the penalties and other remedial measures that are imposed on you. And so we spend a lot of time talking with clients, not only about specific issues they have that come up and taking them very seriously, but in addition, how they can sort of fine-tune a broader approach to compliance that will hopefully reduce their risk, and if not reduce their risk in a specific instance, then at least allow them to sort of mitigate the penalties on the backside. I think what banks can do, speaking generally, is transfer risk. That is the business, in many respects, of banking. It's the business of really any intermediary. What they can't do is make risks disappear. And so if there's a belief out there, as there is a strong belief with evidence that climate change is occurring, then I think it would be reasonable to look at banks as well as other financial institutions and say, all right, what are you doing to sort of address the risks that we perceive? I think they can help other companies mitigate them. I think arguably they could prepare themselves, with the review of their asset portfolios, try to understand what projects they're funding might be susceptible to climate risk, things like that. But what they can't do is sort of holistically, achieve climate goals. I think that would be a whole of government, a whole of society approach. And so I find some irony in the fact that, without necessarily asking Congress, without passing a law, we have unelected regulators basically saying this will be the climate policy and you must follow it. And I would say that there's a substantial likelihood of a challenge to some more affirmative rulemakings in that space because they might not be fully lawful and they might have required an act of Congress because they are, in the lingo of the Supreme Court, and I'm no Supreme Court litigator, but I know many, major questions that Congress has to speak to. So I think that financial institutions need to respond to regulatory incentives right now, which is to say, have a plan to address ESG, deal with it. That will be the case for public companies as well. But I think in trying to manage that, they also have to sort of look at what are ways we think the government is going too far and asking too much of us. Because I got to tell you, banks alone, financial institutions alone, cannot reasonably be expected to sort of substantially change the trajectory of climate risk. Banks do a fantastic job of transferring risk. They don't make it disappear.